Okay, so picking back up here with learning objective 4, now let's look at the requirements for statutory law and the possible defenses. So learning objective 3 was all about common law. What do the plaintiffs have to prove? What kind of defenses are available? Now we're going to look at statutory law and look at the same set of things. So now we have a couple of big laws here, right? The Securities Act of 1933. And so here, this was one of the first cases. It established a precedent. And essentially, if you don't know what an S1 is, that's basically just a filing that you have to put out that's going to be for your registration statement. And so the auditors couldn't even establish that they had exercised due diligence under this case, right? And so this was significant. Under the Securities Act of 34, there was another case. So Ernst & Ernst was the predecessor to EY a long time ago. And this basically established that auditors couldn't be held liable under this Rule 10b-5 for ordinary negligence. And so in this case, they had to show that knowledge of the fraud had to be proved. The auditors had to know about it before you can recover under these provisions. Okay, so we'll kind of work our way through here. And especially when we get to the next learning objective, we'll kind of compare the requirements for those two. But just for kind of laying out the groundwork, we have Security Act of 33, Security Act of 34, and now we have this Private Securities Litigation Reform Act of 1995. And this limited the amount of auditor's liability by getting to this proportionate liability, right? Which is, if you're an auditor, that's what you want, right? You don't want to have to pay for another party's share of this misrepresentation or whatever the lawsuit is alleging, okay? And so they limited it that based on the kind of investors that were bringing the lawsuit. So it could be under these certain small investors, they still might have this unlimited joint and several liability as far as possibly being on the hook for the entire lawsuit amount. But then to most other investors, the liability was limited to where they couldn't exceed 50% of the share of the losses, right? And so, or 50% of the losses. And so those are the three acts: the Securities Act of 33, of 34, and then this revision through the PSLRA of 1995. Okay, so kind of going a little bit deeper here into these statutory acts. Now, what are the requirements for liability under the two Securities Acts? And so this is a nice little summary here, figure. I think this is a helpful one. And so if you look here, this kind of shows the what do you have to prove, right? And so it should be straightforward. You always have to prove a loss, right? That just makes sense. You always have to prove that the financial statements are misleading in order to try and bring a claim against the auditors. But the difference is in this reliance on the financial statements and then the standard of liability. So the 33 Act says you don't even have to prove reliance on the financial statements, right? And so this one actually shifts the burden onto the auditor. The auditor is basically having to prove that they did due diligence. So if I'm a trial lawyer, this is what I want to have to show. I mean, this is the one I want to be able to bring as a third party. I got to show there's a loss, right? Financial statement, and I have to show that the financial statements are misleading. So I look for errors in financial statements. I look for big stock market drops in the price around disclosure of misleading financial statements, and boom, I've got my two right there. And then I don't even have to show that that the shareholders relied on those financial statements. Now I'm going to shift the burden to the auditor, who has to show that they have engaged in due diligence, right? So that's kind of the lowest bar for bringing a lawsuit, and it kind of shifts the burden to the auditor. So under 1934, with the Securities Exchange Act, they do have to show that the party relied on the financial statements, and they have to prove this intent, scienter or scienter, I don't know how you say it. It's basically they have to show that auditors had an intent to deceive, manipulate, or defraud, right? So basically auditors were colluding with managers to create these misleading financial statements. That's a really hard thing to show, right? So if I'm a trial lawyer, I probably am less likely to bring this act unless I really have a good smoking gun, right? So this is under Section 10. Okay, and then lastly, looking at another piece of the 34 Act. So the first one was under Section 10, this was under Section 18. And the reason we have these different sections is because these allow for different amounts of losses to be recovered, right? And so that's why there's variation in these three. And so the under this 34 Act in Section 18 still have that same requirement to show reliance, but now all you have to do as an auditor is just to show that you have good faith, right? And so if they prove good faith, then they're fine. If the trial lawyers can show that they didn't act in good faith, then that's when they open themselves up to liability. So looking at the RICO Act, this is still statutory, right? This is still law passed by Congress. And so mail fraud and fraud in the sale of securities are included in these racketeering activities. And this is used against CPAs who basically had some knowledge or should have known that there were some material misstatements in the financial statements. And again, why would I bring different, why would I care about this as a trial lawyer, as you get a lot more damages than you could from a civil case, right? So if you bring this case under the RICO Act, then you can get a lot more damages than you would under common law. And so one of the key cases here, initial cases that helped interpret this, is that the court decided accountants can't be held liable unless they actually participated in the operation or management of the organization, right? Trying to provide, again, some cover for the accountants. And again, we have a predecessor of EY here, Ernst & Young, and basically trying to show that they can't be sued under the RICO Act unless they participated in operation or management of the company, right? Trying to give, again, some cover here. And you can see some of the cases here that related to this criminal liability approach. This is one with Continental Vending. There's another one with, a little more recently, Arthur Anderson. It was back in my day when I was in public accounting. And there was some information that suggested that they had destroyed some information. And so that's where they got the obstruction of justice from this, but they brought this under some of these SEC acts and other statutory acts, and it was later overturned actually by the Supreme Court, but the damage is already done, and Arthur kind of ceased to exist as a public accounting firm after the initial conviction. They were even kind of shedding clients even before the conviction. Once they were brought up on charges, then clients actually started to jump ship at that point. So some other sources of kind of where liability can come in. Some of this actually gets to individual, not just kind of liability for the audit firm, but also for the individual CPAs. And so the SEC can actually restrict CPAs from reporting on financial statements of registered SEC firms. It can keep CFOs from being able to be a CFO on a publicly traded company, or wouldn't be able to sign off on any filings. And same thing for the auditors, right? So that's a type of liability, right? It's a little more personal, and it can be done at the CPA firm level as well. And it also requires the auditors to report these illegal acts that they might have found out about from the client if the client doesn't report them. So the client is required to submit these 8Ks, these Form 8Ks, that are used for a lot of different activities, but they're usually like material significant activities. So they're required to report those, and if the auditors find out they haven't, then they're supposed to report that to the SEC. The PCAOB is also another regulatory agency that can have some liability for auditors, where They can investigate the CPA firms that are registered with them. Remember we talked about that in one of the professional topics from earlier, and how the CPA firms have to register with the PCAOB in order to do an audit of an SEC firm. And so they can, the PCAOB does these inspections, and they can have disciplinary proceedings if they find out that the CPA firms aren't conducting audits appropriately. And so they can have monetary damages. They can suspend them from actually auditing any of these publicly traded companies for a period of time, and can remove them and basically nullify or cancel their registration to where they could ever engage in audits of publicly traded companies. And they can refer criminal cases to the Justice Department for prosecution. Right? So those are another sets. They're still statutory in the sense that SEC was created by Congress, the PCAOB was created by Congress, and so they're still statutory in that regard. And then kind of the last learning objective is this legal liability for accounting and review services. I'm not going to spend much time here, if any time really, just recognizing that there are some additional guidance out there related to things like compilations and reviews, and so those are lower levels of assurance, and compilation is not assurance at all, right? It's preparation, and so there is some liability that's out there related to making sure that the firms are performing the activities they're supposed to, and how they do have some additional rules they have to follow, and they basically do have some potential litigation that's possible in these situations. But ultimately, I'm just going to summarize these last couple slides. Ultimately, if you are using due care to execute these engagements, you're using in pretty good shape, and if you know there's a high risk of there being a problem with a given client for exercising an extreme amount of due care in those situations, then that will also provide you with cover in terms of the liability, right? Because there are some clients out there that are very risky, and they still require audits, right? And so the law kind of recognizes that, but obviously they increase the requirements for the auditors. And what's going to happen? Auditors are going to now charge more, right, for those because of the higher risk and the higher requirements. Okay. All right. So that's kind of that's our topic on legal liability. Again, ultimately, this is a really big driver of how auditors plan and execute the assurance engagements in the way that they do. It's because there's a pretty significant cost that is possible if these audits are not conducted appropriately.